Welcome to the lecture on campaign finance, and this is going to be kind of laid out in a timeline with some coverage of needed vocabulary. So you need to understand that while I start these notes at 1971, the U.S. Congress has attempted over several years, starting in the early 1900s, to deal with campaign finance. A lot of the original laws prior to 1950 were dealing with corporation contributions and labor union contributions, but they had done some things. But in 1971 and again in 1974, Congress passes the Federal Election Campaign Act. The 1974 was a update to the 71 law in regards to, or in light of, what was learned about how campaign contributions were illegally dealt with within the Nixon administration. Okay, so this law, the Federal Election Campaign Act, also known as FECA, established that there would be limit campaign expenditures. So in this case, this is a personal, the candidate themselves being able to donate or give money to their campaign is what it wanted to do. It wanted to limit how much an individual could loan their campaign. They also wanted to limit their direct individual contributions. So this would be from the public. A citizen within the United States, how much can that individual donate to a candidate? They wanted to put a limit on it, and they wanted to put a limit on direct interest groups donations. So interest groups were not covered under previous campaign finance limits. One of them was corporations and the other one was labor unions. And interest groups, lobbying groups, are different. We're in a different category. So this was going to put a limit on how much they could donate to an individual candidate. And then finally, they were going to require that candidates publicly disclose their donors. So they would have to make sure and allow access to the public, to all the constituents or anyone in the country, access to who had donated to their campaign and how much was donated. Okay, so a couple of things off of this, some terminology you need to know. So when we talk about limits on campaign funding, that is known as hard money. And it's because it's limits. There's strict limits on how much you can donate. Today, the limit on direct individual contributions is $2,900, maybe $3,000. It gets adjusted for inflation. But this is just hard money. What gets donated directly to the candidate, and there are very strict limits, so it becomes known as hard money. There's a hard line on how much you can donate. Now, also, when we talk about that limit direct interest group donations, that is for political action committees. What came out of that was, okay, we're going to limit how much an interest group can donate to a campaign, but we're going to allow the lobby groups, the interest groups, to create what are called political action campaigns. And so the political action campaigns will register directly with the FEC, which we'll talk about what the FEC is here in just a moment. And then the political action committee can donate directly to the candidate. Now there are limits. There's a hard limit. It's hard money on how much they can donate to the campaign. And we're $5,000. We're not talking millions from these interest groups. They do severely limit it. Okay, so because we're putting all of these limits on it, we're requiring them to publicly disclose it. it gets turned over to the executive branch. How are we going to require these things? They ask Congress to create a committee, Federal Election Commission committee/commission. It is an independent regulatory agency. We haven't talked about these yet. We will talk about them much more in depth when we get to the bureaucracy chapter with the presidency. But just know that an independent regulatory agency has a lot of independent oversight for themselves. The president is not as involved in these commissions. It is a group that are leading these commissions. It's not a single person. They get legislative power. They get what's called quasi-legislative power. They have to establish rules that need to be abided by so they can implement the law. But then they also get what's called quasi-judicial powers, meaning they get to determine punishment for anyone who breaks the rules, the regulations that are established. But that's the job of the Federal Election Commission. They have a website, fec.gov, that you can go and you can see who's donated money to candidates at the national level. Their job is to enforce federal election laws and spending. Okay, now, in 1776, we get Buckley v. Vallejo. And this is where the Supreme Court first established that money is speech. Now, it is related and linked back to a much earlier case back in the 1920s, maybe 19-teens, referred to as the Santa Clara case, in which they refer about corporations and whatnot, and having rights, like under the First Amendment. But this case was about was challenging the constitutionality of the Federal Election Campaign Act. And this is where they established that giving money, donating money is a form of speech. So the Supreme Court affirmed, supported, agreed to, upheld the individual and the Political Action Committee direct limits. So those hard money limits that was established in the Federal Election Campaign Act laws, those were constitutional and were upheld. They also upheld that the public had a right to know who was donating to the various candidates. So that was upheld. What wasn't upheld what was deemed unconstitutional, a violation of some rights, specifically the First Amendment right, is the candidate expenditure limits. So they basically said, if an individual wants to donate their whole entire net worth to their campaign, they can. Loan their campaign their entire net worth and become poor, they can do that. The government can't stop an individual from doing that for their own campaign. But the government can limit that type of action for the citizen to give to a candidate. Okay, this also established the idea between what is known as expressed advocacy, which in the rest of these notes I abbreviate as EA, and that is usually candidate supported campaign materials. So all the ads that you will see or hear, that says, "I'm Blev Nation and I approve this message," that would be an expressed advocacy because you're expressing support for a certain candidate. The candidate is saying, yes, these are my views. There's also this thing called issue advocacy, and that is, using an issue: environment, immigration, abortion, gay marriage, marijuana, taxes, military spending, you name it, pick the issue and create a advertisement for it and make a candidate look positive or negative in that light. Okay, that is different. Okay, and those don't say that a certain candidate's paid for the ad or supported the ad. They usually will say a lobby group or a political action committee, or what is known now in today's terms, a super PAC, which we will talk about later. Now, Buckley v. Vallejo did allow, so they said the direct hard limits on direct campaign money is illegal. But they didn't go a step further and deal with money directly to the political parties. And so an individual could give unlimited amounts of money to a political party. And then in turn, the political party could use that money for get out the vote activities. So we're going to hold a rally. And at the rally, we're going to connect individuals to our candidates. Okay, but we're really doing a rally for getting out the vote, to come register, to get excited about election day. Get out the vote, encourage people to get out and vote and get registered and those sorts of things, but we'll also have our candidates there. So it's an indirect kind of campaign rally. That was unlimited. That's known as soft money. So anytime the money is unlimited, it is soft money. So the political parties could use the indirect support for the candidate. Okay, so they're going to do issue ads. Here's the issues that we support, and here's the candidates and how they feel about it. But it's indirectly for those candidates. I hope that kind of makes sense. I'm going to break these notes here, and I'm going to do a second set of notes over the rest of this because we jump forward several decades in our campaign finance laws. So if you have any questions, let me know. And remember, don't do anything too stupid.